So we're going to hear now from Harkindeep Kaur from Guru Nanak Dev University about teaching law in times of crisis, the roadmap for India. And as usual, if you've got any questions, please put them in the chat box. Okay, over to you.
So my topic is teaching law in times of crisis, the roadmap for India, because India has also been badly affected during COVID-19 due to sudden lockdowns of the education institutions has put a great weight on the learners in this country. So the uncold pandemic situation in the country led to the closure of education institutions. Providing education was imperative for the state even during the lockdown. So again, there was need for a balance because containment of the virus was the main priority of the government. So no guidelines were as such issued from the government of India for the purpose of dealing with education in the times of crisis. So as far as if I go about the Constitution of India, the right to education is a fundamental right which is enshrined in the Constitution of India. Even if we see education from the human rights perspective, the right to education is the basic need of every individual. So right to education has been elevated even in number of international instruments. It has been elevated to the level of human rights. Constitution of India, Article 21A is a fundamental right which provides for free and compulsory education between the age group of 6 and 14 years. As far as online education is concerned during the pandemic, I think this age group was the more which has suffered because engaging these children who are very new to the technology was a great task for the educators as such in India. So the Universal Declaration of Human Rights 1948, it also provides for right to education under Article 26. Then education is free at least in the elementary and the fundamental stages, and opportunities. This is what the Universal Declaration of Human Rights talks about. Opportunities for higher education, they shall be accessible to all on the basis of the merit. Then response of law education to crisis. So during crisis, making education available was also an important task, but due to sudden lockdown, sudden curfews and other things imposed during the pandemic, this was a thing which went on the back's mind of the legislators who were actually dealing with the health problem in the country. So during crisis, it was imperative for the education institutions, organization that they need to adapt themselves to the novel ways of teaching. Sudden outbreak was also created a strange situation both for the law teachers. Especially, I'm confining my study to the law only. So there was a strange situation which was created for the law teachers and the students. So educational institutions, particularly the law schools, they need the help of the student learners that they can adapt themselves to the modes of teaching which were being adopted in the times of crisis. So the information technologies, they has been extensively used during the crisis period to cater to the needs, educational needs of the students, and the education institution, they need to build competencies among the students. So we cannot take a back seat even when there is a crisis. So education being a fundamental right, as far as India is concerned, we need to cater to, we need to build competencies among the students even during the times of crisis. So during pandemic situation made the education sector that we need to evolve new ways of teaching and imparting law. So sudden closure of the education institution led to evolvement of new pedagogy for teaching, and education institution, they also made a shift from traditional classroom teaching to the virtual classrooms. So because it was a pandemic situation, the first of its kind, which India has not suffered on such large scale before. So health was a main priority, but at the same time, the education could not be ignored. So the crisis has itself changed the way of teaching and learning. Inclusive teaching talks about that we know law student that has to be deprived of education, any of the grounds. It can be the digital divide, it can be any other reasons that people are not having access to the IT things and all that. So blending of face-to-face and online inclusiveness was required during the times of crisis, and the crisis also puts responsibility on the public authorities that we have to make the law schools, the colleges and universities to make the imparting of education a reality, to make these institutions to that, because all these, the conservative institutions, the traditional institutions, even they are lacking the infrastructure also, that they cannot adapt themselves to the new ways of teaching and learning which evolved during this era of crisis. So public authorities need to provide framework support to the law schools in their endeavor to adapt themselves to this changed environment of education during the times of crisis. Now, as far as the roadmap for India is concerned, so education too in India suffered a blow due to crises which were caused by the pandemic. So India being a country with diverse culture, there is a diversity which is based on the culture, religion, language, different socioeconomic conditions are prevailing. So we were more in India were concerned with dealing with the health problems rather than dealing with the educational problems which the people at across the region they were facing. So educational institutions they were shut down without laying down any guidelines for continuous education even during the crisis. So health being the prime, the priority for the purpose of dealing with the containment of the virus when the sudden lockdown was imposed in India. So the education institutions they were closed down without giving any kind of guideline from the legislative side, from the government side, that how the education has to be dealt during the times of crisis. So the schools, the education institutions on their own, they have evolved new methods of imparting education to the students. Again, the digital divide, it has further worsened the situation for the vulnerable disadvantaged students because in India, even people who are living in the urban areas and we compare them with the rural areas. So people are lacking in infrastructure as far as the rural areas are concerned. So schools and colleges to cater to the needs, education needs of the students, this suddenly we made a shift to the online mode of teaching because we were transformed from the physical classrooms to the virtual classroom. So this was all in all a very new thing for the students to face, even for the learners, for the institutions also who were lacking the infrastructure to deal with such kind of situation. So this flipped classroom teaching was new both for the teachers and the learners, and the law schools they adopted online classes, modes of video conferencing to fulfill the basic education needs of the students. So, in a country like India, the use of technology by the teachers and the student, it's in the nascent stage only, particularly if we talk about in the rural sector. So, the teachers, they have to be equipped, they have to be given a training for the use of ICT tools for imparting education. And as far as the law schools, colleges, and universities in India are concerned, we are governed by a body. That is the Bar Council of India. This is the statutory body which deals with what kind of education, what kind of syllabus, what kind of curriculum has to be followed. So even during crisis, the BCA has given only some general instructions only. They have not given some specific guidelines on how the education has to be made a reality in the times of crisis. So uniformity about the modes of teaching cannot be adopted. Already I have told this thing that there is a lot of diversity which is prevailing in India. So in such situation, uh, adopting a uniform mode of teaching could not be adopted because some schools, if we compare the government schools, we compare the private entities, there is a lot of difference between the infrastructure between the schools which are sponsored by the government and the big schools which are run by the private entities. So lack of infrastructure, internet facilities, this is also not same, not uniform in all the law institutions. Some institutions, they are infrastructure wise very good. Some institutions which are infrastructure wise not in a very good position. So there is also digital divide between the government run and the private education institutions. So different online learning platforms, they could not be adopted equally by all the institutions. So whatever things the schools could engage, whatever things the schools could evolve at that point of time, they have taken up for the purpose of imparting education to the students. So the way forward is that the government has to cater to the needs of the schools and colleges lacking infrastructure so that they can meet the needs of online teaching during crisis. The teachers need to be developed skill and competencies in digital classrooms. They need to adapt themselves to the. So we have to come out from our physical classroom teaching, face-to-face teaching to the virtual teaching. So the teachers themselves need to change themselves, need to evolve new pedagogies, and they need to adapt themselves to the digital environment. So the teachers act as facilitators conceptually, technologically, and pedagogically. So these are the three things we need, that the teachers, their role has been changed from the teachers to the facilitators. That how we are going to make the students familiar with the technology through which we are catering to their educational needs. So training of the teachers for blended teaching learning processes required. So the teachers had to be trained both for the already in India we are following a teachers training program for the students, but that is only for the physical classes only. For the blended mode of teaching, we need to we need to train the teachers that how they can engage the students in the virtual classrooms. Again, the learners they also need to adapt themselves because they are taking classes from the comfort of the homes. So from the disciplined environment, moving to the comfort of your home. So the learners also has a double duty that they also have to adapt themselves to this new environment. In the comfort of their home, they have to create such kind of environment that they are following the discipline also, the classroom discipline, the classroom decorum they are maintaining. Then online learning of law also aims that the learners they have the skills to use the technology and they may be provided necessary guidance from the teachers And we can also expect from the government that time to time, the government also has to provide the resources for the purpose of dealing with such situation. So development of new tools and resources in online learning, teachers can prepare their short videos, they can share with the students. E-content is prepared by teachers and collected from sources like OER, lecture series on different platforms. E-content can be developed on different softwares like Screencastify or Docity tutorial. And e-content can be disseminated through Moodle, Swimmer, Blackboard, etc. So this is the way forward through which we are actually struggling. We are still adopting these things, being in the nascent stage of online teaching. So this is all from my side. Thanks for your patient hearing.
Thank you for sharing that with us, that experience of the pandemic teaching in times of crisis. So, as I said, if anybody has got any questions for our speaker, could you please put them in the chat box to address them? If you send them to me in the chat box, and I'll pass them on. But again, I'll start the questioning if that's okay. The question I would ask is, did the students, so when you had to move to online teaching, did the students in their homes or their communities have access to internet connections and the technology they needed?
There was not much internet facilities available to the students who were coming from the rural areas. So they were facing these internet connectivity issues. So we have adopted the, at least from my experience, what we have done during our in our university. So we were taking up the lectures, we were sending our recorded messages through WhatsApp. So students who could not had access through proper internet connectivity, they were having the access through the WhatsApp group. So we have created WhatsApp groups for individual classes, for individual subjects which we were teaching, so that we can interact with all the students. So this is the way which we, at least in my university, what we have done, because even ours being a state university, traditional university, we are lacking in the first class infrastructure, that we were not prepared to meet up with this kind of situation which erupted suddenly. So we were also confined to our homes only. So we also had limited the people who were using Wi-Fi, it was fine with them. But people who were using the internet on their mobiles only, that was a big problem, because students were complaining that after attending 1 hour class, their data has been done away with. So they need to recharge it again and again. They have to pay a heavy amount. They are paying fees also to the university, and they are getting their mobiles recharged from their own pockets only. So this was financially also a burden on the students. So this is also the one aspect that we need to look on. So recently, because since I'm coming from the state of Punjab, the government of Punjab, they have taken up one initiative that they have started giving rupees 2,000 for the internet charges to the students. That people who cannot afford, so we are giving you this much money, you need to attend your online classes. Because people being poor, they were not able to get a recharge of 150, 200, 250 bucks. That was also a great crisis, which we have seen in our online classes. This is my
Yeah.
humble submission.
Yeah. So when you said you used WhatsApp, was that sort of text discussions in WhatsApp, or were you using some kind of video in WhatsApp?
We were actually initially, when this lockdown was imposed, we were sharing some recorded videos with the students on the WhatsApp, and then we were recording our voice and we were sharing that with the students. Because then in between we started using the Zoom platform, but that also could not accommodate so many students. So that was also a problem in itself only. So we have been tried to engage the students in one way or the other by giving them having a one session with one class through the Zoom, because it was charging also. The university need to pay for it also. We were only getting 40 minutes free trial only, that thing. So we were relying on that thing only, because everybody, the institutions were not prepared for such kind of thing, that the education institution, they are going to be closed down so easily and without any guidelines from the government. So this is without any help from the government, that the university, they evolved their own system so that the future of the students is not hampered. So whatever means we got, for example, we were taking attendance through this Google Drives, we were sharing the notes through the Google Drives. So all these things, whatever technology was available, whatever technology we were given training or at hands, we were using it. We have taken use of that during the crisis.
So you chose the technology that would fit, that would work for the students. And tell me, how did it go did you ask the students afterwards what they
The
thought of
difference that
exercise?
I have seen with the student, because after giving our lectures, we have taken the online examination. We used to email the question paper to the students, and students sitting in the comfort of their home, they need to send us their answer sheets.
Yeah.
Now we are taking physical exams. So the one difference that I've seen, that students have become so used to online a system of examination, they can't write a single thing in their answer sheets. Now this is the you can say the bad thing that we have seen, because nowadays the examinations are going on in my university, and we cannot see that students, they are not able to write a single sentence. They are
Yeah.
not learning, because they have become so used to, at least for 2 years they have given their examination sitting in their homes only. It was an open book exams. So we used to mail them the question paper, we used to receive the answer sheets, then we are evaluating, so they are writing everything sitting in the groups only, so it was more comfortable for them. Then now the difference is that they are so much used to this thing that giving physical exams has become a very difficult thing for them. So we need to take them from the virtual to the physical background now. This is what is required.
Yeah.
That you are not made for virtual, you are made for physical exams only. We are made for face-to-face teaching only. Unless and until we are very much developed in infrastructure, bring all the facilities which are may be provided by the government, may be provided by our universities. Now, my university is having 25 departments. It's not easy for them to provide infrastructure to each and every department. So these are the certain limitations which I myself has noticed during the time of crisis.
Yeah.
I hope you're satisfied.
Yeah. Well, yes.
Anything else you want to ask?
And now that you're in India, you're past the crisis. So
Yes.
now you can go back to face to face.
Yes, yes.
Yeah.
So now we are taking face-to-face classes. Now the examinations are being done. They are being done in the physical form.
Right.
Yeah, students are coming, they're giving their exams for 3 hours. But then also I told you the difference, that because sitting in the home, writing an exam from the book was easy for them. Now learning and coming to the department for the purpose of exam has made them very hard to cope up. This is
Yeah.
more from their side. They cannot cope up with this thing that we have to give the exams after learning it, after reading our textbooks.
And are they coming back to class? Do you find that
Classes, they're fine.
they're fine?
Yeah, they're fine, because they're happy after 2 years. They're moving, they're visiting the campus, they're meeting their friends and face. So from that point, but only from the examination point of view, they are having reservations.
Right.
Because it's easy to pass in the online exam than in the physical exam.
Yeah. And then you've got cheating problems, I guess.
We got lots this time, and this is the first time we are witnessing this thing.
Yeah.
We didn't witness this thing before the crisis. So after the crisis, I've told you one thing: the students, they have become so familiar with online exams that now they are resorting to every kind of online cheating in the exams. They are bringing slips in the exams. So we physically are searching the students so that they are not carrying any kind of helping material in the this. So technology has helped also in the this during crisis, but the other side is that the both sides of the coin, there we have to see that it is pros and cons are also there. Students will take another 1 year to come back to the classroom teachings, and they need to go back to your textbooks for the purpose of giving exams.
Well, thank you very much indeed. So I'm afraid time's up, but thank you very much for your presentation.
Thank you, sir. Thank you so much.
Thank you. And then the next presentation is going to be by Professor Ahmar Afaq, Professor Jimmy, I'm sorry, I don't know this, Jimmy Jones from Symbiosis Law School. And you're going to talk about the dearth of emotionally intelligent legal professionals, exploring the use of AI in legal education. Over to you.
Thank you very much, sir. Professor Jimmy, if you can please share the screen. Thank you very much. So greetings to one and all present in this session. I am Afaq, along with my co-author and co-presenter, Professor Jimmy Jones, is here to present our research type paper on the topic, the dearth of emotionally intelligent legal professionals, exploring use of AI in legal education. So before going ahead, I would like to share a brief history of how the legal education has evolved in India and what is the current position of legal education. So as the August participants must be aware that in India, we do follow the hybrid legal system, where we have a blend of common legal system along with the civil law. And this all have started with the establishment, but the majority of the legal system we have, it owes much to the common law system. And it is because of the the legal system established by the Britishers in India, we have taken it forward. The kind of legal system which were prevailing prior to them from the ancient Indian times or in the medieval India, where we have witnessed the Delhi Sultanate, then the Mughals and so on, they surrendered to the common legal system. And with the establishment of the first court in Bombay in 1672, it was the establishment of or kind of commencement of the legal education in India. So very later in 1961, we came up with the Advocates Act, and by that very particular act, we have created a statutory body, which is known as Bar Council of India. And that is the body which regulates, which is having the power to conduct both the legal and education and as well as the profession of lawyers in India. So starting from the admissions, what practices to be involved, ethics, privileges, curricula, and discipline like requirement of a mandatory 75% attendance in the your academic year, everything, all kind of rules are provided by the Bar Council of India in this regard. If we can move to the next slide, please. So now, how the BCI is, looking after this whole legal education in India. So we have a system where all the universities which are imparting legal education or the law schools which are imparting legal education, they need the recognition and accreditation from the BCI. Till the time the recognition is not there from the BCI, they cannot go ahead with the legal education. So they have provided with certain guidelines and requisites which we need to satisfy, like we need to have an infrastructure facilities. Then there is a specific ratio of teacher per students. Then other basic facilities like the library, number of books, and specific subjects which they wish to take up as in a law school. So all these things are being taken up by the BCI. And what they have done to cater the needs of the legal profession, they have incorporated the clinical subjects like legal aid, moot court training. Then they have made a mandatory service internship in the curriculum. Apart from that, if we wish to have these clinical courses, we have to come up or we need to go with the regular moot courts. So we are having the internal moot courts, external moot court, national level moot courts, then similarly the mediation competition and so on. So basically the legal education in India have been developed a lot in the previous last 2 decades, especially with the integrated courses of BLLB, BBLLB, now BCom LLB, BSc LLB coming to the fore, which we owe much to the Professor late Madhav Menon. So all these requirements need to be satisfied, and for this purpose, the BCI have constituted the Legal Education Committee who regulates the standards of the LLB degree. Apart from it, it has also constituted the Curriculum Development Committee and the Directorate of Legal Education, which keeps a tab on for the upgradation of the standards of the legal education. Now, apart from this, the higher education or the education otherwise is being taken care by the University Grant Commission in India. So, by the 184th Law Commission of India report 2002, which was pertaining to the legal education and professional training and proposals for amendments to the Advocates Act 1961 and the University Grants Commission Act of 1956. It reviewed the structure and the regulations which were governing the professional legal education system in India. So by the 184th Law Commission of India report, it was recommended that both UG, BCI and UGC, they need to remain equal partners in the legal education in India. There will be a role of a bar. bench as well as the academia vis-a-vis regulations of legal education, which need to be balanced by the LEC. So on these recommendations to constitute a committee on legal education, and there need to be 3 faculty members common to both the committees. These all recommendations were provided, and what they have envisaged that there need to be effective consultation between the BCI and the universities as a three-tier process. The first one, that the first consultation on the proposal regarding legal education would be between BCI through its legal education committee and the State Bar Council. So we have the Bar Council of India and the State Bar Councils, which are for the respective states in India. After which the proposal would be considered by the UGC Committee on Legal Education, and as a final stage of consultation, the proposals would once again be deliberated by the BCI Legal Education Committee. So in this manner, we have a wholesome system provided by the BCI, that is Bar Council of India, which is taking care of all the legal educations in India. And a point which I would like to highlight here, that they have incorporated the clinical subjects so that the students can be trained, they can be equipped with the relevant tools so to cater the needs of the legal profession. Right. So over to Professor Ji. Professor, you need to unmute yourself. Give me a moment. Just give us a moment.
Yeah, I think I'm able to.
Fine, thank you.
Yeah, thank you so much. So the idea behind introducing everyone to the background of the structure and the system in which legal education is being provided is primarily to understand also the impediments and hurdles that we have in actually inculcating something like emotional intelligence, which has not been really into the fore of most of the discourses. So emotional intelligence, something that we'll be dealing in some time, which came in 1990s itself, and there's an importance which is associated with emotional intelligence. And apart from that, we have of lately social intelligence, cognitive intelligence also that are being discussed. Now, there has been an emphasis with which professional skills have been talked about, primarily because law education being a professional course, and with the shift to the 5-year program that we had from the conventional 3-year program based on the US model of legal education. We have had the courses, the mandatory courses, and apart from the clinical courses that have been there. However, we understand that particularly in a scenario of developing a situation, what we have are certain crises, primarily in the context of inequalities that are there in the access of resource and that translates into the infrastructure that is available. So the major dominant instructional mode has been the conventional method of lecture itself, and of lately there have been attempts that have been made in engaging the teaching learning processes beyond the lecture method, that is primarily through class discussions and presentations. Some other methods that are being relied upon are role plays, which it also includes like giving a situational problem and primarily asking the students to take certain like display certain emotions, primarily based on what would be the possible responses that the clients may be taking. Apart from that, we have mood court exercises, simulation exercises that have been used to a limited extent. Now, this is all in the background of a lot of constraints that primarily a teacher is situated in, primarily with the constraints of time, and also with the context of how equipped is the person in primarily engaging in the clinical courses. Unfortunately, what was attempted through the incorporation of clinical courses, which has been mandated by the Bar Council of India, was in infusing the students through with practical skills, has been unfortunately being rendered by the regular teachers and not practitioners, and hence the treatment that the courses are being given are primarily as what we have with the conventional theory subjects that we have. Similarly, we have a very limited extent of avenues that are made available to students in something that is very important, that is like negotiation skills, primarily like dispute resolution skills, or maybe understanding what is impasse, what is the conflict that is at in the first instance itself. And these are in some manner being addressed through like courses like on alternate dispute resolution that is again mandated by the Bar Council of India. Unfortunately, with all of these steps, what we have is that what we provide and the quality of legal education that is being provided and the goals and the objectives with which it is being introduced and being given to the students and the requirements of the bar and the industry, there's a huge gap. It is still not being addressed. And there are manners in which even students post their completion of the 5-year courses have to undergo training at the law firms or situations like that. And hence that is where we understand that there is definitely a gap between that. Apart from that, what we primarily associate legal education and legal profession in India has been with the constitutional values that we have. And accordingly, we understand that how do we ensure that the law seeps into the grassroots is essentially through legal profession. Now, there are a couple of things that I would mention about emotional intelligence, considering that it is something that comes primarily under the domain of psychology, has been widely being understood and is being utilized in management disciplines and all. We understand emotional intelligence in a twofold manner. One is like recognizing, understanding, and managing one's own emotions, which may include like motivating oneself in the face of frustrations, controlling one's impulses, delaying gratification, regulating one's mood. And the other fold is primarily in the context of recognizing and understanding and influencing the emotions of others. This is something that we will primarily understand that if the audience is familiar with mediation, we trying to understand the conflict that is on the surface may not be the actual root cause of the conflict. And there may be something that is not visible for the third person who's trying to negotiate or trying to resolve the conflict. And it is there where we have emotional intelligence as very important component there. So we have this coming somewhere in the 1990s and has been further developed by Daniel Goleman, who mentions a research that was conducted in Harvard Business School, and which refers to, and we understand how IQ is something that has been excessively be relied upon, and hence we see that the instructional methods are being primarily in transmitting legal knowledge through maybe reference of theory, case laws, and incorporating comparative methods, but very little on emotional quotient. And the research is referring to how emotional quotient counts for twice as much as IQ and technical skills combined in determining who will be successful in the context of the reason why we have mentioned this is the context of how we need to. There has been a lack of focus primarily on how primarily in legal education in general, from the legal education in general. Further, we have studies in 1997 which tries bifurcating, segregating, categorizing emotional intelligence into perception, assimilation, understanding, and management. And unlike IQ, which is something that we believe is in stone, which cannot be increased or decreased or something in that context, we have emotional intelligence, which is a skill which one can develop. And EQ can grow throughout our lives, and hence the context of how the need to emphasize on incorporate and rely and the reliance on emotional quotient in legal education. We have further studies primarily that tries to link the importance of emotional intelligence in the context of legal profession, and that linkages help in understanding why there is a need to infuse the contexts of emotional intelligence into the legal education as well, through courses or through workshops or scenarios like that. And the studies that have mentioned are like effective lawyers are not only skilled intellects, but also excel at questioning, interviewing, communicating and persuading, planning and managing, resolving conflict, entrepreneurship, working with others, making ethical decisions, all falling in some manner being strengthened by emotional intelligence. There is, and with legal profession particularly, we understand that there is an inviolability and there's something that we can never get rid of is primarily interpersonal skills and decision-making skills, which are essential components for effective lawyering. And hence what the emphasis has been, how emotional intelligence is important for one to be a good lawyer. And accordingly, for in ensuring that the legal education is matching with the requirements of the legal profession, why emotional intelligence should be incorporated in the legal education. So we have the conventional ways in which attempts have been made, little attempts, like baby steps that we see in the context of simulation exercises or role plays. Um, but we see that more formally, we have emphasis on emotional intelligence through courses, and that we have something with the 2014 annual meeting of Association of American Law Schools by the American Bar Association, which offered a program EQ, what it is and why it matters. So something coming very off, like very lately seeping into the discussions of legal profession or the requirements of legal education. We have other instances of how emotional intelligence have been, in some extent, being incorporated uh, in University of California, Berkeley on social intelligence, University of Miami School of Law on mindfulness, University of Chicago, that School of Law that has courses on leadership. So we have also some studies that are there in the top part of the slide, which is again trying to contextualize the importance of emotional intelligence in legal profession. So we have a study from a paper that is referring to from 2016 that says like refers like law firms and clients recognize the importance of one's emotional quotient skills when deciding which attorneys to hire or retain. And other that we have is with reference to the judges, the context of importance, not only limiting to the bar, the litigation, but also to the bench, and the context of emotional regulation for judges. So there are no steps that has been mentioned in 2011. No steps for emotional regulation for judges have been undertaken. It states that our legal culture does nothing to promote intelligent judicial emotional regulation and much to discourage it. So the context why, what we are trying to argue in some manner is how we can use AI in inculcating something that is very inviolable, that is emotional intelligence. What we have is restricted practices as of now. What we have is role play simulation exercises that has a direct human interface, and apart from that we have a lot of constraints that includes time, with the context of the completion of syllabus, the context of examinations and all. And what we may have as an impediment is the lack of flexibility with the instructor in ensuring that the students are having an interface with the diversity of responses that may possibly be there with the same set of conflicts. So the context is, in order to diffuse conflicts, understanding conflicts is pertinent, and for which one has to be ensured that the emotional intelligence of the person involved is sufficiently high, so as to understand the context and the background in which the person or the party may be situated in. What like I was mentioning is conventional methods have constraints of time. There is a lack of diversity and representativeness, primarily in the context of for an example, if we have role plays or a simulation exercise that is primarily trying to talk about mediation exercise on a hypothetical situation between a husband and a wife, the kind of responses that even in the role plays or the simulation exercises that the students may be engaged as a husband or as a wife and as the mediator, the responses would be limited. And what we may have is maybe a simple example, like how maybe if the individuals involved are have a patriarchal mindset deeply embedded, even the responses in the simulation exercise and role plays would also carry forward the same. And accordingly, this is something that would be carried forward in the legal profession as well, which in the context of larger goals of justice is not something that is something that we can really get rid of. We have limited interface with pluralism, primarily in the context of possible alternatives to the same conflict through different responses. And we have definitely subjectivities of individuals that percolate in such exercises. An example, like I had mentioned about the patriarchal mindset that may be deeply embedded. Apart from that, maybe a lack of experience of me. So for an example, if I have had not an interface of caste discrimination and the dispute in hand that I'm supposed to be undertaking is based on something related to caste discrimination, we understand that how my responses and my approaches would be very constrained and restricted, and would not be something that is positive in the larger understanding of achieving the objectives of legal education. The idea of incorporating artificial intelligence is primarily ensuring that there's more time that can be provided to the students beyond classrooms. So something that we have as an attempt that has been made in India was by a law school in India, New Walls, National University of Advanced Legal Studies, Kochi in Kerala, which tried incorporating somewhere into 2021, trying to incorporate gaming technology in legal instructional methods. So the idea was incorporating certain methods of drafting and responses and the alternative approaches to the same given problems that may have been conventionally had a treatment only to classroom lecture methods. Definitely, that is only one attempt that has been there, and the successes or the failures is something that we are yet to know, primarily in understanding how accessible it is, how beneficial it has been. So with AI being brought into, it would definitely aid and support in making these simulation exercises more representational, in the context of ensuring that there is a manner of universality of possibilities that are infused into the program, so as to ensure that the diversity is something that the students who are interacting or having an interface with AI are able to have an understanding of that. Definitely in that context, the context of the broadening the perspective that the students have of multiple outcomes, the same problem. It can also be in the context of our understandings of the notions of development. Maybe as a simple example, how we perceive maybe living in a city is more beneficial than living in the villages, which is not maybe the truth or of a universal application, and hence the context of broadening the perspectives. And definitely with those interfaces and interactions with the technology, the students would be definitely at least be able to having an experience and an interface with alternative experiences, alternative solutions to the same given conflict. In a scenario of a global society, definitely the emphasis of maybe culture in some places, religion on some contexts, the diversity of experiences that other individuals in other countries have. Those are certain things that can be incorporated through AI, which may be a conventional Indian law teacher may not be able to give it as an interface. Definitely, we have a lot of challenge. The previous presenter had definitely mentioned about the digital divide. And also we must understand that with reference to India or the context of how the fourth industrial revolution has been with the previous industrial revolutions are not something that would be uniformly be available and accessible to all individuals in the countries. And accordingly, something that we can always try understanding that although most of our discussions have been limited to India, but this is something that we can definitely draw parallels with other third world countries and also institutions that have low funds. And those are realities that we must engage with even in developed countries. So something that maybe Professor Upendra Bakshi refers that with the context of countries or the third world in general, we have first world in the third world and third world in the first world. So similarly, we have elite institutions even in the third world countries who may not have these difficulties in access of resources or economic funds in general, and also similar contexts of how maybe legal education institutions even in developed countries may not be able to have provided to all these law students in generally in that context. So we have definitely the problems of how even if the benefits of the previous industrial revolution and the AI will not be populating equally to all individuals because of the systemic inequalities that we have. Economic factor is just one criterion. We definitely have a lot others in that context. And with that, what we would definitely have the interface that would be there with AI, with legal educational institutions would not be uniform. It would be non-uniform in a given city, in a given country, and definitely when comparing between different countries, then definitely would differ. Again, the challenge would be like, would we have trained instructors to monitor the same? Because with the benefits that AI has, there are also certain challenges that we would have. And accordingly, in ensuring that it is smoothened, their context of employing people, again, would context of more economic liabilities on the legal education institutions. This is something that is very abstract and fascinates in general, like how we may not even neutrally view AI or any of these technologies very neutrally, because unfortunately, someone who's coding these also has certain biases. So what in a factor we believe that the AI would be giving a more universal interface and representational understanding of the possibilities to a given conflict may not be really there with the context of limited approaches that the coder may have had. We have definitely a context of apprehensions of the teachers of whether AI would actually substitute them. This has been there with the previous industrial revolutions as well. And we have a large labor workforce, and definitely that is one thing. But beyond all of these, we have the greatest hurdle that we have is the existing structures that we have, which includes like the non-representational context of academic representation in bodies of the Bar Council of India, which continues to be in some manner being dominated by legal professional advocates. And we have certain developments even with the context of the expanding ambit of Bar Council of India, which has been again being criticized. So again, those are certain hurdles. And this is something that is a larger goal before which we would have a lot of other hurdles that includes like ensuring that we bridge the digital divide that exists in the country. Yeah, that is from our end. Thank you.
So thank you very much for that presentation. That's great. Can I just remind participants that if you've got any questions for our speakers, please put them in the chat box. Send them to me. Actually, we've overrun the time, but because we're missing one speaker, we've got a little bit of unexpected extra time. Whilst I'm waiting to see if any questions in the chat box, so can I just ask, is there any existing system that does what you want? Is there any AI that can be used? Oh yes, you're muted.
Yeah. So none as of now. The incorporation or the use of AI has been to an extent entered into the context of legal profession, primarily in contract drafting and other such avenues, but none that is talking on simulation exercise and role plays.
Right.
That is what our understanding is. But yeah, so it's a very distant goal, like I mentioned, because since our previous presenter has always also from India itself, we have a lot of other challenges that we have before we read something that we talk about incorporating AI in primarily in legal education. Access in the context of accessing it is something is definitely going to be a big hurdle. Before that, definitely the questions on whether there are any existing technology, something that we do not have. Something that I was mentioning, but that there is a gaming technology that was introduced in New Kochi, Kerala, which they introduced last year, wherein the understanding was it definitely there's a fun aspect to legal instruction method as well. But apart from the larger idea was like talking about the possibilities on how about the taking up, it's like a game. The students would have to choose, take decisions, and accordingly materialize things without directly hampering someone's interest, which one would do once in legal profession. So that is something that we are only familiar with.
Yeah, but actually AI itself, so it's something that I get the feeling in education in general, there's like a hope that one day AI will do wonderful things for us. Like it'll mark our grade exams and give feedback, but it's still some way in the distance. And I don't think anybody has, as far as I know, anywhere has got kind of anything like this just yet. Is that fair? Do you think that's right? It's still, there isn't actually any AI at the moment anywhere that can do these things.
So the attempt was very futuristic. It's very futuristic, but definitely I think with time these would percolate into legal education. It is going to be inviolable, primarily in trying to understand that the representational context, like so primarily we may not have diversity in a classroom, We may have for an example, in an all-female college, maybe in ensuring that there is an emphasis with which we sensitize with the male counterparts may be difficult. But or maybe in a classroom where maybe there is none of the students from an economically weaker section or a socially weaker section. The context of incorporating AI is at least an attempt in sensitizing them with this varied set of things. So for an example, what we definitely understand in a situation where there is an instance of domestic violence, the woman would want to get rid of it and would want to remain in those relationships. We definitely understand the challenges in accommodating that idea. But in a system, particularly in understanding the context and the situation where the client is situated, the woman is being situated, we would be better able to understand them. The discussions is it is definitely another discussion whether it is right or not, legally and morally and other things are different, but at least it is accommodating alternative perspectives. That's the broader idea.
That's great. So thank you very much indeed for your presentation.